So the Northern Irish Feminist Judgments Project is a project of over 30 academics, 30 more commentators, where we look at judgments and we ask ourselves from a feminist perspective, how could they be different? So original judgments across a broad range of areas where we ask, well, what would the woman question be here? How have women been represented? How stereotypes perhaps have been used, where the woman as the mother has been put forward rather than the woman as an active political actor perhaps, or as somebody as a worker, or where women don't fit that stereotype, have they been portrayed negatively because they're not mothers? Or more broadly, how we describe what should be in the public sphere, what should be in the private sphere, what the family, is that something private where the state shouldn't interfere, versus the public sphere, where we ask ourselves those key questions in judgments while sticking very strictly to methodology. So we follow all the rules of judgment writing around things like precedent, so we follow all the previous case law. We don't change the law itself. We're very strict on the methodology, but we ask ourselves, what would a feminist do? This is particularly important in Ireland because up to the mid-1980s in the Republic there were no senior women in the judiciary, and only this year in 2016 has there been an appointment of women to the senior judiciary in Northern Ireland. So it is a very important and significant question for Ireland when it comes to judgment writing. So we cover a wide range of cases, from constitutional law to equality, education, land law. We cover this wide range, but the idea is that even some that you wouldn't necessarily think are important from a feminist perspective, we use to demonstrate actually it is significant across a whole range of areas. So my own case, the McGimsey case, was about brothers taking a case against the Anglo-Irish Agreement, which was the first case in the peace process in Northern Ireland. Because they were politicians and public figures, that was what the court thought was important in them taking that case. Whereas when I rewrote it, it was about asking, well, would somebody who wasn't such a public figure, who perhaps was a housewife, would they be considered as important in taking that case? We also cover cases like the McGee case, which was about access to contraception in the early 1970s in the Republic. We talk about several cases to do with abortion, like the X case and cases from Northern Ireland on that topic. And also the case in Ree White, which was about schoolgirls going to Holy Cross School in Belfast, and the type of intimidation that they faced as girls, which in the original judgment was largely ignored, that the protesters used things like pornography to intimidate them as young girls. So there's a range of areas, everything from education to equality to employment, so that show that asking that feminist question is important across all areas of law, not just the one. So together with the other two project directors, Julie McCandless of the LSE and Mairead Enright of Kent Law School, we've drawn together a broad array of people, both academics but also practitioners, artists and advocacy groups into the project. What we're hoping to use it for, there's three strands to that. So the first is in education in universities, where a lot of the cases are quite important and significant in their areas of law. So in your contract law class, when you do that contract case, that you read this other case as well, this other example of how that judgment could have been had, just to show that there are alternative voices, that the single judgment isn't the ultimate way that this case had to be described. So we're hoping that in education in universities it gets used. We're also hoping that practitioners, so solicitors and barristers and judges themselves, will use it perhaps to develop other alternative arguments, particularly because we were so strict with the methodology, that these are justifiable and usable legal arguments that can be put forward. We're also hoping that advocacy groups, because they were involved with the project from the beginning, will also perhaps use them in their attempts at law reform, both through the courts when they take cases themselves or are defending people in cases, but also for a form of legislation and constitutional reform as well, that they can see that these are the kinds of arguments that are possible, that are out there, that they can themselves use. So we have the outcome of the project at this point is a book that's coming out of Heart this year, which contains all the judgments and some commentaries and some introductory text to get more detail on the project. And more details of those are all available on our website, which is www.feministjudging.ie, where we outline more of the materials and more information about the project. But what we're hoping is to get people talking about what judges have done within Ireland, what judgment mighting has meant over both jurisdictions, and to think about what a feminist judgment could actually do for law in Ireland.